Now.
No. Before I begin proceedings, I'd like to say a few words about today's proceedings. New clauses and amendments are grouped in two groups for debate. This is to enable two clear and coherent debates on aspects of the bill. Shortly, I will call the member in charge to move her new clause 10. Debate on the first group will take place on the question that new clause 10 be read a second time. If that question is agreed to, I'm minded to select Amendment A to new clause 10 in the name of Rebecca Paul for separate division. We have more than 90 members who have indicated that they wish to speak in the first debate. Not all honourable members will be called. It is not customary to impose a speech limit on private members' bill, but I hope that members in charge of the bill and the Speaker after that, members will restrict themselves in the early part of the debate to no more than 15 minutes in the first instance, and that includes taking interventions, and it will have to drop accordingly thereafter. The Chair will review that guidance, as I say, as the debate progresses. We need to ask for shorter speeches to enable more members to contribute. I shall make it clear that the Chair retains the right to impose a formal speech limit, but I'd rather colleagues help each other. This is a very important debate. This divides in different ways. So please, today is an opportunity, primarily, for backbenchers. I do not expect to call front benchers to speak till at least 1:30. So we will now begin with new clause 10, with which it will be convenient to consider other selected new clauses and amendments in Group 1 as listed on the selection paper. I now call Kim Leadbeater to move new clause 10.
Yeah. Thank you, Mr. Speaker. It's a privilege to open the debate on this next important stage of the Terminally Ill Adults End-of-Life Bill. It seems a long time ago since we held the second reading debate back in November on what I think many of us felt was a very proud day for Parliament, where we saw an emotional and passionate but largely respectful debate on what is a hugely important subject which means so much to so many people. Mr. Speaker, I know that there are a range of views on the subject of choice at the end of life. And I know that today is not about revisiting the fundamental principle of assisted dying, but as the sponsor of the bill, if I may, before I address the amendments in my name, I will make some brief introductory comments as to why we are here. And put simply, if we do not vote to change the law, we are essentially saying that the status quo is acceptable. And over recent months, I've heard hundreds of stories from people who have lost loved ones in deeply difficult and traumatic circumstances, which show that that is clearly not the case. Too many have seen their terminally ill loved ones take their own lives out of desperation or make the traumatic, lonely and costly trip to Switzerland and then face a police investigation while dealing with their grief and loss. I will give way.
I thank my honourable friend for giving way. She mentioned many real stories influencing this debate. I'd like to mention just one more from my own constituent, Mick Murray, who is in the public gallery today. Mick helped two close friends, Bob and Anne, make the painful journey to Dignitas. Both simply wanted to die at home with dignity, surrounded by loved ones. Instead, they had to make that journey overseas at great cost and legal jeopardy. Mick said, "I helped them out of compassion," and I think that is what is missing from the current law. Does my honourable friend agree with Mick?
Please, we're going to set the example by following the rules of the House. Short interventions, not speeches. There's a lot of other members.
Thank you, Mr. Speaker, and I thank my honourable friend for that intervention. And it was a very powerful point, if slightly long. But it is an important point that there are people who are facing these really traumatic, difficult decisions every day, including Louise Shackleton, who I believe is also with us today.
A point of order.
I thought the debate was to discuss amendments and not a general debate.
It is about that, but I think this is the opening leading to the amendments. But I will make the judgment of that call. Kim Leadbeater.
Thank you, Mr. Speaker. If I may just finish that point, I will give way.
Can I just say to people, if we're going to have continuous intervention, don't be shocked if you end up at the bottom of the list if you continue to make people making the same intervention. I just want to help people, because all you're doing is soaking up time. Jim Shannon will be a good example.
Mr. Speaker. I'll always be at the end, so for me it's very important to ask an intervention. Can I ask the Honourable Lady, at the second reading, she set the scene very well, but since then things have changed. For instance, the Royal School of Psychiatry has said that they have voiced strong concerns opposing the bill. They talk about in regard to judicial oversight, robust protections against coercion, etc., and the effect it will have upon those vulnerable groups, those with dementia, Down syndrome, mental illnesses. Does the Honourable Lady not respect those viewpoints of my constituents who tell me they're opposed to this bill in principle and all the things coming forward? And this, I feel, doesn't address the issue the Honourable Lady is referring to.
Kim Leppy.
Thank you, Mr. Speaker, and I thank the honourable gentleman for his intervention. He's absolutely right. There are a range of views on this issue, and I'm deeply respectful of that, and I take all those points into consideration as we embark upon this debate again today. And perhaps, Mr. Speaker, most importantly, I've spoken to terminally ill people themselves over recent months, and I think it's impossible to know what it must feel like to receive a terminal diagnosis. And I have nothing but admiration for people who have bravely spoken about their personal situations, some publicly, including, of course, Dame Esther Ranson, and others who have done so privately, many by emailing their MP. And I know mine is not the only inbox full of those emails. I also want to thank colleagues here in Parliament, of course.
Thank you for giving way. Will my honourable friend distance herself from the correspondence from Dame Esther Ranson, who accused those of us who have concerns about the bill as having undeclared religious beliefs? Many colleagues found this distasteful and disrespectful.
I thank her for that intervention. I haven't seen those comments, but it's absolutely right that whatever our views are on this issue, we must remain respectful. And I also want to thank colleagues here in Parliament, MPs and indeed staff, who've shared their personal stories of loss with me over recent months. These are, and this is a really important point, these are real people with real stories, and they must always be at the heart of the debate. Mr. Speaker, public support for assisted dying in this country has been consistently high for a long time now, and we've seen movement in jurisdictions around the world, including, of course, just this week in Scotland. And I want to congratulate colleagues in Holyrood, and particularly Liam MacArthur MSP, for such a compassionate and respectful debate, which I hope we can emulate here today. It is right that we consider this change with great care, as we are doing today. But we should also remember, as with other big social changes, like giving women bodily autonomy regarding their reproductive rights, or allowing gay...
Order. Thank you. We did say, as we've had this conversation, a very early introduction. I think that's why members will begin to get frustrated. We should be now speaking to the amendments. Kim Leppard.
Thank you, Mr. Speaker. I will move on to those amendments. If I can just acknowledge the work of the Bill Committee in relation to those amendments, because there was a huge amount of work done by members across the House with a range of views.
Look, I'm really bothered because it's the day for the amendments, and we really need to understand the views of the amendments. And as the member in charge of the bill, I'm sure that you really want to get into the depth of the amendments and not continuing the work. Kim Leppard.
I do indeed, Mr. Speaker. You're absolutely right. But the amendments that we're discussing today do build on some of the work of the committee, and as such, I think that is important. We took a lot of steps to strengthen the bill during the Bill Committee, and I was pleased to work collaboratively with colleagues in that way. Mr. Speaker, and again, as I come on to those amendments, which have been tabled in my name, the Government is, of course, neutral on the issue of assisted dying, but has always been clear that workability is essential if the bill is to pass. So I've worked closely with an outstanding team of civil servants from the Department of Health and Social Care and the Ministry of Justice, and it is with their technical advice regarding amendments tabled today to make the bill workable and to give coherence to the statute book that I am tabling these amendments in my name. Of course.
Friend for giving way. Would she confirm that those civil servants are 100% comfortable with the impact of this bill with people of disability, mental health issues, neurodiversity and other medical conditions, and the fact that they will not be coerced or under pressure because of this bill? I
thank you for that intervention. I mean, the civil servants are clearly neutral on the issue, so they They certainly haven't expressed any opinions with regard to the content of the bill. What they have done is merely provide the technical advice and expertise, and have done so brilliantly in that regard. So I come on to new clause 10, amendment 52 and new schedule 1 tabled in my name. Mr Speaker, as well as correcting the injustices in the legal situation, one of the key tenets of this bill is choice. Choice for dying people. But it's also very important that there is choice for doctors, other healthcare professionals and indeed anyone else. The bill was always clear that no registered medical practitioner or other health professional is under any duty to participate in the provision of assistance in accordance with the Act. But this new clause expands that protection. It broadens the people to whom it applies and the functions to which it relates. It also introduces new Schedule 1, which makes provision for enforcement of this right not to be subject to any detriment in connection with the bill. Mr Speaker, of course I will.
I'm very grateful to her for giving way. Does she accept that there may be a weakness in new Schedule 1 in as far as it protects a person from actions taken by their employer? It may not necessarily protect, say, an agency worker who is contracted to perform a service, but then the original medical body decides not to then re-engage that person's services.
I thank you for that intervention. I would refer him to my previous comments that the bill and these clauses and these schedules have been drafted with the highest level of legal expertise, so this isn't something I anticipate as being a problem. Of course.
The bill does allow applicants to shop around for doctors. Yes. And it strikes me that there is a danger that some doctors will specialise in the provision of that service, who might have an ideological view of this bill, giving it rather greater scope than she intends.
I reject the assertion that patients will shop around. Bearing in mind we're talking about dying people, they're not in a position to start shopping around for services. But I also agree that the bill is particularly strict in that regard. There are very strict protocols to be followed that doctors have to follow. I'm just going to make some progress, if I may. So this isn't just about patient choice, it's also about choice for professional people as well. And again, we know there are a range of views on assisted dying across a range of professions. And I've always been clear that no one who is uncomfortable taking part should have to. And nor should there be any detriment to anyone, whatever choice they choose to make, in whatever role they have. New clause 10, I will give it.
Well, thank you very much to my honourable friend for giving way. It's welcome that this new clause seeks to protect more individuals, but can she say why she's still not chosen to make provision for hospices and care homes to opt out without having their funding threatened?
I thank the honourable for giving way. There is absolutely nothing in the bill which has got any suggestion that any funding would be impacted by whatever decisions organisations make around assisted dying. And I'll make some progress, Mr Speaker. New clause 10 subsection 1 states very clearly that no person is under any duty to participate in the provision of assistance in accordance with this Act. And this is something I feel strongly on a personal level. If people don't want to be involved, they shouldn't have to be involved, and those that do should. Subsection 5 covers pharmacists and pharmacy technicians, and new Schedule 1 provides comprehensive employment protections. So I hope that whatever colleagues' views are on assisted dying, they will see the value of these changes and support them. Yes.
I'm very grateful to her for giving way. I thank her for these amendments, because a number of people have written to me concerned about the very issue that she is raising. Does she agree with me that there are many people who will just be opposed to assisted dying in all its forms, and I entirely respect that. But if that is really their objection, they should be honest about that and not pretend that it's only particular amendments they need. And really, they should make the argument that they really want to make.
I thank him for that intervention, and I agree. We must be respectful, but we must also be honest with each other. Mr Speaker, in relation to Amendment A to new clause 10 from the member for Reigate, who I would like to thank for her work on the Bill Committee. I understand the thinking behind this amendment, but I worry that there are unintended consequences in terms of patient care and protection. And I've been advised that that is the case, which I think the Minister will speak to. I think there is consensus across the House that in the interest of patient safety, it's vital that there is clear and open communication and sharing of information between healthcare professionals and within the assisted dying process. If an employer can stop their whole workforce from participating in any sort of assisted dying services, it could prevent the sharing of information or the recording of information in a patient's records. And this could be in relation to safeguarding and could put patients at risk as a result of the employer's decision. Terminally ill patients may be receiving different treatment at different places from different healthcare professionals. And if they were not able to transfer information or records, it would potentially be harmful. And there are workability issues with the amendment. It's not clear how it would work with regard to the requirement of professionals in subsection 7 of new clause 10 in terms of providing information to an assessing doctor about a patient, someone who they may have previously treated, or in relation to information about a specific condition they may specialise in. This information would need to be provided in the interest of patient care. An employee will always be bound by their contract of employment, of course, but flexibility is needed, as many health and care professionals work for multiple employers. It's not uncommon for clinical staff to have more than one employer. For example, a doctor may be employed by the NHS, but also work for a hospice, so it's not a straightforward scenario. And just as it would be wrong for anyone to be compelled to be involved in the process, it would be wrong for anyone to be prevented from doing so, particularly if there was an impact on patient safety. So because of these unintended... I will give way.
I thank her for giving way. Before the second reading, I held a public meeting where I heard a range of views from my constituents, and one thing that kept coming up was the need to protect medical professionals from being compelled to take part in assisted dying. I'm really pleased to see that being addressed in new clause 10. But does she not agree, just as she said, that having the choice to take part must go both ways for medical professionals?
I thank him for the intervention, and he's absolutely right, and we keep coming back to that word choice. It is choice for patients, it's choice for terminally ill people, but it is choice for medical professionals and others as well. So because of these unintended consequences, I can't support the amendment, but I am confident that new clause 10 and new schedule 1 provide robust protections for employees, whatever their choices are, about participating in the provision of assisted dying services. I will.
Thank the Honourable Lady for giving way. Would she mind elaborating a little bit more on the detail around the transferring of medical records? Because it's my understanding that you can request your own medical records as a patient.
I thank you for that intervention. I think the patient could request information, but so could doctors and other healthcare professionals, and it would be wrong if they were not allowed to share that information if it was requested, even if their employer was saying that they didn't want them to do it. And I turn to new clause 11 and consequential amendments 64 and 65. These amendments ensure the bill is workable by making provision about the replacement of the coordinating doctor or the independent doctor where the doctor is unable or unwilling to continue to carry out their functions within the bill. The doctor may be ill or on holiday, retire, or have a change of personal circumstances. Flexibility is important for... Of course I will.
What concerns me, thank you, Mr. Speaker. What concerns me about new clause 11 is that essentially people can shop around if one doctor is unwilling. She's given a list of just there of reasons why the doctor might be unwilling, but surely one of the reasons the doctor might be unwilling is they have a fundamental change in the circumstance of that person and don't want to do it. Nothing about that is then recorded. Is that not a real weakness in this bill, this new clause, that actually we don't have that passing on of evidence from one doctor to another?
I thank you for that intervention. This isn't about eligibility, it is about the doctor's change of circumstances rather than the patient's. So if the doctor decides the person isn't eligible, then they would reject the application. So it wouldn't be a question of that. And they would record that in the patient's records, of course. So it would be there, it would be transparent. I'm going to make some progress, if I may. So, Mr. Speaker, this is essential about providing flexibility for doctors, but also ensuring continuity of care for patients, and I hope colleagues can support these amendments. Mr. Speaker, coming to new clause 12, this new clause ensures enough reporting of instances. I'm just going to make a little bit more progress, if I may, because there's a lot of people who want to speak. This new clause 12 ensures thorough reporting of instances where the coordinating doctor concludes that the patient does not meet the strict eligibility criteria as set out in the bill. It's very important that this data is recorded, but at present there's no requirement for the coordinating doctor to produce a report when they are not satisfied of all matters as set out in clause 23 subsection 5, meaning they do not provide the person with the approved substance. This lack of a reporting obligation does not align with the rest of the bill, hence this amendment, which I'm sure colleagues will feel it's very important to support. The report must also set out... I will give way.
Thank you very much for giving way to my honourable friend. Whilst it's important that a doctor's reasons for refusing to provide assistance are noted down, there's nothing currently in the bill that would ensure that if the person made another request in the future, the next coordinating doctor will be made aware of that doctor's report. Can she say anything to reassure those of us with concerns that people who are suffering from mental ill health, including depression, may seek assistance repeatedly until they find a doctor who will assess them as eligible?
I thank you for that intervention, but that wouldn't be an issue because copies of the report would be given to the patient and to the coordinating doctor if they were not in that GP's practice, but also to the Commissioner as well. So that information would be recorded. And it's very important that this data is recorded. The report must set out the reasons. I'm going to make some progress, if I may. I'm trying to be very open to interventions, but I do need to crack on. The report must set out why the coordinating doctor is not satisfied, and it must contain an explanation of why the patient cannot proceed with the assisted dying process. The coordinating doctor, as I've just said, must give a copy of the report to the person. If the coordinating doctor is not a practitioner within the person's GP practice, they must give a copy to the practice and also to the Voluntary Assisted Dying Commissioner. This reflects the thorough and robust reporting and monitoring mechanisms which exist throughout the bill. Mr Speaker, I now come to the other amendments tabled in my name, and I'm going to try and keep my comments succinct, as I know there are many colleagues here today who wish to speak. Amendment 56 ensures that the coordinating doctor gives the Commissioner a copy of the patient's first declaration. This enables the Commissioner to carry out their monitoring responsibilities under Clause 45 of the Bill. Amendments 57 and 61, I will give way.
Thank you, persistence has paid off. I thank the Honourable Lady for giving way. When considering this bill, I had presumed that the doctor concerned would be a senior clinician, a senior doctor, but the impact assessment on page 63 makes reference to pre-registration doctors who've just completed medical school but not yet been fully on a provisional registration. Can she confirm that it's her intention that this bill will be completed by the most junior doctors as well as more senior consultants and general practitioners?
I thank her for the intervention, and given her background, she knows what she's talking about. Look, there would be regulations made which would set out the level of expertise required by the doctor, but there would also be training for every single doctor that took part in assisted dying processes. And that is done well around the world. There's other work that we can build on in that regard. Where did I get to? Amendments 57 and 61 are essentially, Mr Speaker, tidying up amendments which modify the wording of the duty of the Secretary of State in respect of training requirements in clauses 7 and 10, which fits in with the intervention from my honourable friend across the way there. Training is of paramount importance within the assisted dying process, and there will be a period of years where anybody who opts in to be part of this process will have thorough and robust training. Due to amendments made at committee stage with very good intention, the wording as it currently stands would suggest that the regulations themselves must include details about training, which obviously wouldn't make sense and would be unworkable, as it would obviously have to be done separately. Similarly, Amendment 58 removes unclear drafting as a result of changes made at Bill Committee, which could have the effect that the regulations would have to contain training about training, which obviously doesn't make sense. Mr Speaker, Amendments 59, 52, 74 and 62 are also tidying up amendments which are necessary as a result of the introduction of compulsory training for all doctors and all panel members in domestic abuse and coercive control, following amendments tabled by the member for Lowestoft, which the Bill Committee unanimously agreed to accept. Amendment 74 ensures that the term domestic abuse in the bill has the same meaning as in the Domestic Abuse Act 2021, which clarifies the definition of domestic abuse and ensures the term is consistent with existing legislation. This provides for a very broad definition to capture a full range of behaviours, including physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional or other abuse. And it doesn't matter whether that behaviour consists of a single incident or a course of conduct. These are really important amendments addressing concerns around coercion and providing additional layers of safeguarding within the bill. And as such, I hope colleagues can support them. Amendment 60 makes provision corresponding to the provision in clause 12 about the death or illness of a doctor from whom a second opinion is sought for a further referral to be made where, before reporting, the independent doctor dies or through illness or is unwilling or unable to act. This amendment once again ensures continuity of care and is an important detail to add to the bill. Amendments 67 and 68 clarify the provision of this clause in cases where an approved substance requires administration via a medical device. The current drafting of Clause 23 is not clear about whether it is allowable to administer the approved substance via a device, which it is. This amendment provides clarity for clinicians. Mr. Speaker, Amendment 91 expands the duty as to what must be included in the final statements of patients accessing assisted dying services. It includes additional information to be collected, including whether the person has a disability other than a disability consisting of the illness or disease which caused the person to be terminally ill. Data collection and analysis is an important part of the robust monitoring and reporting built into the bill. Mr. Speaker, Amendments 78 and 79 relate to the decisions of the multidisciplinary voluntary assisted dying panels as set out in Schedule 2 of the bill, an important change made at Bill Committee. Each panel comprises of a legal expert, social worker and psychiatrist. Amendment 78 ensures that all... Of course I will.
Thank you, Mr. Speaker. The Royal College of Psychiatrists have stated that they do not feel at the moment in time there are sufficient psychiatrists who would be able to deliver that position on such a panel. What response does the member have to that?
I thank the honourable member for giving way, and the Royal College of Psychiatrists have a neutral position on the issue of assisted dying. If we refer to the impact... Yes, they do. If we refer to, I'll just finish this point. If we refer to the impact assessment, the numbers of people who access assisted dying in the first few years will be very small. I think there are around 4,500 psychiatrists in the country, but there's also a period of time, again, to do the training that's required for those psychiatrists who will be taking part in the process of a number of years. So I wouldn't anticipate any problems there. Mr. Speaker, I'm going to just keep going if I may, because I think I've been fairly fair. Amendment 78, which I was just about to speak to, ensures that all three members of the panel must agree before a certificate of eligibility is issued, so abstentions cannot result in approval. This amendment came about as a result of discussions at Bill Committee, and it's really important to clarify that when the panel of experts are doing their work, their decision must be unanimous in order for a certificate of eligibility to be granted and for the patient to proceed. If a panel member abstains, no certificate of eligibility can be granted to the person. Schedule 2 also sets out that the panel must give reasons for its decision in each case, and this is really important. And Amendment 79 ensures that those reasons, the reasons of the panel's decision, are communicated in writing in a document to the person to whom the referral in question relates, to the coordinating doctor and to the Commissioner. This creates clear channels of communication and will enable those people to fully understand the expert panel's decisions.
Will the member take an intervention?
I'm going to just finish, if I may, because I think other people want to speak. I now turn to Amendment 14 in this group, tabled by the member for Bradford West, another outstanding member of the Bill Committee. And this amendment states that a person who would not otherwise meet the requirements of subsection 1 shall not be considered to meet those requirements solely as a result of voluntarily stopping eating or drinking. Mr. Speaker, I suspect this amendment has been put forward following lengthy discussions at Bill Committee regarding whether people with anorexia would be eligible for an assisted death under this bill. In my previous career, before becoming an MP, I worked with a number of people with eating disorders, and I'm very aware of the hugely sensitive and complex issues surrounding disordered eating, and particularly anorexia. I also know that this is a personal issue for a number of colleagues across the House as a result of their own experiences. Eating disorders cause huge distress for individuals and their families and loved ones. But with care and with the right treatment, it is possible for people to recover and to go back to leading a full and fulfilling life. It's with that experience... Of course I will.
I'm very grateful to the Honourable Lady for giving way on that point. Now, she's absolutely right on eating disorders, but my understanding of the proposed amendment is for those who effectively starve themselves into a position of becoming terminally ill without having an eating disorder. That was the thrust of the amendment. Does the Honourable Lady see that, and how does she intend to respond to it?
I thank him for the intervention, and he does make an important point. It isn't specifically about eating disorders. There is a broader context, and my comments will come on to that. It's with that experience in mind, my own personal experience, and having spoken to many colleagues on this issue, that I said in committee, and I say it again now, that under the bill as it now stands, having anorexia would not qualify a person to be eligible for an assisted death. The bill is clear that a person cannot be considered terminally ill only on the basis of a mental disorder. And Clause 2 makes clear that a person must have an inevitably progressive illness or disease which cannot be reversed by treatment. Anorexia is a serious mental health condition which is not inevitably progressive and can thankfully be reversed by treatment. And of course, at every stage of the assisted dying process, the patient must be found to have capacity to make the decision. This is checked repeatedly throughout the process. Not only would someone with severe anorexia be highly unlikely to be assessed to have capacity to make a decision about assisted dying, the other tragic reality is that if a patient was so ill as a result of not eating and drinking for whatever reason, they would die before the process of assisted dying would be able to take place, as it could take up to I'll just finish the point if I may. As it could take up to 2 months to complete all the stages of the assisted dying process as set out in the bill. And the latest clinical guidance states that the general range of survival, once voluntary stopping of eating and drinking has begun, is between 7 and 21 days. Stopping eating and drinking also leads to a range of symptoms which would make meaningful conversations as required by the bill impossible. However, Mr. Speaker, having said this, I know that some people have expressed concerns that the severe physical consequences of a decision to stop eating or drinking could still enable someone to claim eligibility for assisted dying when otherwise they would not be able to do so. And I believe that is the motivation behind this amendment. I'll take one final.
Right. Very kind. Thank you. Obviously, the woman's outlining the case for those who have problems with their eating and they're on diets, and then they become almost to the point where they're unable to make decisions. The Honourable Lady's outlining what's going to happen here. What would the Honourable Lady say in relation to Belgium, where they have legalised the assisted dying for those who have problems with their eating disorders, and same in Canada? So the progression goes away from where the Honourable Lady has said and goes away beyond that, because the world has proved that in other countries.
Yeah, and I thank the honourable member for his intervention. The eligibility criteria within this bill are very different to the jurisdictions which he'd mentioned, and people with mental health conditions are not eligible for assisted dying under the provisions of this bill.
The member take an intervention?
I'm just going to finish this point, if I may, because it is actually a very important point. So I acknowledge the concerns that colleagues have expressed around this issue, and I believe that that is the motivation behind this amendment. And as I've set out, I think that risk is negligible. And having taken advice, there is some concern that clinicians might have difficulty in assessing with certainty that the decision to stop eating and drinking was the only reason for a person's terminal prognosis. As such, it might be that some further drafting changes may be required in the other place if this amendment is to pass. But with that in mind, and to ensure that no matter how small the reality is, of there being any sort of loophole, I am happy to support this amendment today. Mr. Speaker, I'm conscious. I'm going to leave it for now, if I may. Mr. Speaker, I'm very conscious that there are many colleagues who wish to speak in this important debate, and I'm keen to hear their contributions, so I will conclude my remarks there. I thank colleagues for listening, and I hope they're able to support the amendments in my name today, in the interest of strengthening the workability of the bill and providing greater flexibility and safeguards for patients and professionals. Thank you.
No obligation to provide assistance, etc.
The question is that new clause 10 be read a second time. Rebecca Paul.
Thank you, Mr. Speaker. It is a privilege to speak in this place on such an important bill, after having been part of the committee that scrutinised it line by line and on some occasions word by word for several months earlier this year. It is a pleasure to see so many of my colleagues from Committee Room 10 in here today, a reunion of sorts, and I'm here, as always, with the intention of improving the bill so that if it does indeed pass, vulnerable people are as protected as they can possibly be from unintended consequences. It's important to remember that during this stage and third reading, we are not voting on whether we agree or not with the principle of assisting someone to end their own life. Our role is to vote on the law in front of us, whether the words on the page are clear and do what is intended, whether the statutory process is safe, and whether ultimately the provision of assisted dying benefits our communities. I am one of those people who is not against assisted dying in principle, but I am against this bill. And I'm happy to put on the record now that I have no personal religious beliefs. I'm against it for this simple reason. It will harm far more people than it will help. And those people that will be harmed are the most vulnerable in our communities. And I'm not willing to accept this collateral damage. So today is important as we have the opportunity to improve the safeguards in the bill so that some of these groups are better protected. And I urge members to take that opportunity to the full. It requires very little skill to draft law that works for 90% of cases, but there is much skill in ensuring that the other 10% is catered for as well. I urge everyone to set their standards to the highest today and think about how we can ensure those unordinary and unexpected cases are adequately protected too. It really is life and death, so please don't accept anything that isn't good enough. I will, of course, give way.
Honourable friend for giving way. Would she agree with me that one of the greatest risks in this bill is around coercion? Yeah. And it's not just coercion from family members or friends, but societal coercion and circumstances. And the current state of palliative care in our country is one of the worst in the developed world. And without adequate palliative care, patients might feel pressure to go down the assisted dying route instead of seeking adequate care.
I thank the honourable gentleman for that intervention, and I wholeheartedly agree. Mr Speaker, there is much to discuss today and little time, so I will start at the beginning of the bill at the point where criteria for eligibility for an assisted death is set. It is here where important safeguards are needed to ensure those who should never be eligible are excluded. We should not make the mistake of assuming that a doctor will always make the right decision or that they are infallible. It is incumbent upon us to put in place law that makes it harder for them to get it wrong, that makes it harder for someone vulnerable to fall between the cracks. I will, of course, give way.
I'm very grateful to her for giving way, and she just agreed with the point made by the honourable gentleman. It's exactly the same point that was made back in 2016 when this House voted against it. Would she say that the following 9 years after voting against the bill saw a golden age in palliative care as a result of voting against that bill? Or does she think, actually, if we wait for palliative care to be perfect, we might actually, once again, never vote in favour of assisted dying?
I thank the honourable gentleman for that intervention, and the evidence is clear that palliative care does not get better when you introduce assisted dying. We saw that in the Bill Committee, and we absolutely should be looking to address palliative care because that will benefit more people. And I will come to that in my speech, so I won't discuss any further as I don't want to get ahead of myself. And there are many helpful amendments in this vein, namely new clause 16, new clause 9, amendment 80, amendment 14, amendment 38, amendment 81, amendment 24, amendment 30 and amendment 31. In simple terms, these amendments seek to tighten and refine the eligibility criteria for an assisted death by setting out when an assisted death should be allowed and for what reasons, and ensuring that those who are vulnerable are protected from something that may not be in their best interests. Interestingly, at the time of second reading, the argument being put forward for an assisted death was to spare those who were dying from unbearable pain. This is an argument that everyone understands and has full sympathy with. No one in this place wants people to endure pain as they come to the end of their life. I certainly wouldn't want that for my loved ones or indeed for myself when my time comes. But then the arguments put forward changed. There was less emphasis on pain and more on choice and autonomy. Yeah. The word autonomy came up again and again in the Bill Committee. And autonomy is important, of course, but up to a point. We have moved from a proposal to provide a humane end to someone's pain when it can't be relieved in the last months of their life, to providing an assisted death service to those who choose it for any reason, even if the pain can be alleviated by palliative care. But this approach comes with a cost to others, family, clinicians and broader society. This really is momentous. There is no going back from such a massive shift. A move to autonomy, trumping everything else, changes everything. And that is why I have tabled amendments. I will give way to my...
Extremely grateful for Mr. Giving way, and that is why her new clause 16 is so important. Because in other jurisdictions who have passed laws like this, up to a third of people, 1/3, report that they've taken this step because they feel they're a burden on others. That's the truth of it. It's not always about pain, and that's the kind of autonomy which leads to disaster.
I thank my honourable friend for making that point, and he is, of course, absolutely right. And that is why I have tabled Amendment 80, to bring this bill back to its original origins and intentions. My amendment requires that in order to be eligible for an assisted death, the pain and discomfort experienced or expected from the terminal illness cannot be reasonably relieved to the person's satisfaction through palliative care. This amendment seeks to limit assisted death to the very small group of people that may benefit from it, not the larger group that actually just needs adequate palliative care to give them the comfortable, dignified death they deserve. I will, of course, give way.
Thank you very much for giving way. The amendment that the member speaks to has put down speaks about severe pain and discomfort. And there's a reason why the medical profession haven't gone for that. How do you propose that we assess severe pain and discomfort as opposed to medium pain? How is a fungating wound part of severe pain or discomfort?
I thank the honourable gentleman for that intervention. I think really the key point here is that we need to be improving palliative care. That's really what we need to be doing here. But we spend so much time and effort on introducing and focusing on this rather than doing the thing that would actually help more people in this country. And my amendment, in combination with my honourable friend for Runnymede and Weybridge's amendments 30 and 31, would drive significant improvements to palliative and end-of-life care, getting us closer to consistent and universally available care for all. I will, of course, give...
I thank the honourable lady for giving way. And just to speak in support of her amendment, because it is, as the Royal College of Psychiatry pointed out, that pain from unresolved physical symptoms can actually make a person want to die. That fear of physical pain or death, often depression is missed, and it's also associated with wish to die. So will the honourable lady agree with me that it's absolutely vital that people are supported to be as free from pain and by having access to good palliative and end-of-life care, and that this provision is only available to those for whom it cannot help?
Yep. I thank the honourable lady for that point, and I do completely concur with the point she's making. The current... I will, of course, give way.
Can I commend the honourable lady for bringing this forward? She's absolutely right to do this. The rejection of amendments to protect palliative care and hospices to facilitate assisted suicide services on the premises for ethical or practical reasons. That bill leaves hospices with little choice but to comply. It also puts them in a very, very difficult position when it comes to funding, and also then it means that the hospices have to provide a staff member to do this work. The issue for and the problems that it creates for palliative care and for hospitals cannot be ignored, and this bill goes against that right in its totality.
I thank the honourable gentleman for that point, and I agree, and I will be coming on to that in more detail in the second half of my speech. I will, of course, give way.
I thank my honourable friend for giving way. And with regard to these amendments, we are so blessed to have our precious NHS, and at vital stages, quite rightly, the NHS delivers care in obstetrics, gynaecology, neonatology and paediatrics. But at the end of life, around 70% of care is delivered outside of the NHS, largely by charities. And that figure, Mr. Speaker, is even higher for children's palliative and hospice care. So the state pays for how we enter this life, but not for how we depart. There is something deeply wrong about that for our society. So does my honourable friend agree that surely we must address that issue first and address the delivery of universal palliative and hospice care
before we go anywhere near this assisted dying bill?
I thank my honourable friend for that very good point, and I agree. In the interest of time, I'm now going to progress. The current situation we have now, where fully funded palliative and end-of-life care is not available in certain postcodes, means those unfortunate patients do not have a real choice. We know that 25% of the people who die in this country do not have the palliative care they need. That is more than 100,000 people a year. And if this bill goes through, they will now be offered a fully funded assisted death as the only reliable way to end their pain. That is no choice. But I urge members who want to see improvements in palliative and end-of-life care to vote in support of my Amendment 80 and Spencer 30 and 31 if they are pushed to a vote. I won't, because I've not got much time. I now want to move on, Mr Speaker, to the lack of the best interest test in this bill, which is what my new Clause 16 seeks to remedy. Patient autonomy is of course important, but it must be balanced against what is in someone's best interest. So in certain situations, when it's in the best interest of a patient, treatment can be given against a patient's will. For example, force-feeding a young girl with anorexia. This isn't an easy balance to get right, but currently, in the absence of any best interest test in this bill, following the process rigidly will lead to devastating results in some cases. The current bill prioritises autonomy of the patient in a specific moment of time, rather than what might be in their best interest in the long run. It makes no allowance for the fact someone may feel a certain way temporarily due to other considerations. For example, when someone has just received a terminal diagnosis that can be understandably cause a depressive state and suicidal feelings. But those feelings don't necessarily last, so it may be in the best interest of the patient to allow a little time to pass, give a little breathing space before considering the assisted death route. I have tabled new Clause 16, which essentially tries to provide this best interest test by excluding certain reasons that may be driving a patient's decision rather than alleviation of pain. For example, we have heard a great deal about the internal pressure from patients themselves driven by concerns of being a burden. And we heard clearly in Bill Committee that a patient can tell a doctor that they are only wanting an assisted death for financial reasons, and they will still be approved. We know from overseas territories that often patients will opt for it because of social and welfare issues, such as being homeless. I'm sorry, I don't have much time and I do wish to progress and get through my points. How can we be happy with a process that doesn't exclude such reasons? Instead of providing the support actually needed, the state is content to put them on a pathway that leads to their death. I hope this House will recognise that whether you support assisted dying in principle or not, it's morally bankrupt to not have some kind of best interest test to protect those who aren't seeking death to alleviate pain from a terminal illness. Another group that is particularly vulnerable is those with eating disorders. In Chelsea Roth's oral evidence, she set out that at least 60 people around the world have been euthanised or assisted in suicide, with anorexia nervosa listed by name as a terminal condition. To paraphrase her, these were young women who were not terminally ill and had decades of life ahead of them. It's important to make the point that someone suffering... I would love to give way, but I...
The honourable lady said she's not... Please, just... The honourable lady said she's not giving way. The thing is, we're aiming for 15 minutes. It's going to be 20 if we don't pick up. Rebecca Paul.
I do apologise, but I do want to get through my speech. It's important to make the point that someone suffering with anorexia, or indeed any mental condition, is not intended to be eligible for an assisted death. However, in the case of anorexia, there are physical manifestations of the illness, such as malnutrition and diabetes, that might mean the patient meets the definition of being terminally ill. And that is the nub of the problem here. The bill doesn't adequately rule out physical manifestations caused by mental illness. That's why the Honourable Member for West Bradford's Amendment 14 is so important. It ensures that anyone who voluntarily stops eating or drinking isn't eligible for assisted dying. I support this amendment strongly as it addresses a big risk. And lastly, on eligibility specifically, I want to talk about capacity. There are such problems with the current approach to determining capacity that I barely know where to start. When it comes to ending one's own life, there should be a higher standard applied. The current definition of capacity was not created with such a monumental decision in mind. And if this were being drafted from scratch today, it would look very different. This is one of the reasons the Royal College of Psychiatry does not support this bill. Under this bill, a person is assumed to have capacity in the first instance. A clinician only needs to be over 50% sure that a person has capacity. If that person is making unwise decisions, that is not taken into account. And a person can be helped to make a decision, for example, when a patient has learning disabilities. So I ask you all today, are you happy with that? Does that sound like a robust approach to assessing whether someone has capacity to make the decision to end their own life? Let's begin with the starting presumption of capacity. This is too lax a standard for assisted death decisions. I therefore support the Honourable Member Bexley Heath and Crayford's Amendment 24, which disapplies a specific piece of the Mental Capacity Act for the purposes of assisted dying. And one of the biggest issues for me is the fact that the current approach requires an impairment of or a disturbance of the brain for someone to be considered to not have capacity, irrespective of whether they can make a decision. So in the real world, Mr. Speaker, what this means is that a doctor could assess a patient who gives the impression of being confused, illogical, erratic, inconsistent. Everything about them could scream they're not in a good place to make this decision at that point in time, but they will still be considered to have capacity if there's no identifiable impairment or disturbance of the mind or brain. This potentially puts those with depression, anxiety, learning disabilities, eating disorders, or even those just experiencing physical pain that's driving them to distraction in danger of being considered to have capacity when they do not. Right, so far as focused on eligibility, I'm now going to talk about hospices. Hospices and my amendments to them.
Sorry, please. I really do want to get many people in. Please, if we can come to a conclusion, would be very helpful.
That's great. Just wind up. Just wind up. Okay. Just wind up.
I therefore wish to talk in support of some of my amendments, specifically that support new clause 17 and new clause 18 in my name provide important protections for hospices that are currently lacking in the bill. New clause 18 makes it crystal clear that any regulated care home or hospice can decide whether or not to provide assisted dying on their premises. And new clause 17 makes it clear that they cannot be subject to any detriment for not providing or permitting assisted deaths, and that their public funding cannot be conditional upon them providing this service. Mr. Speaker, whether you're in favour of assisted dying or not, we must preserve the rights of organisations, companies and charities to choose whether to offer it. They must never be forced into it by public funding being conditional upon the provision of assisted dying. I note new clause 10 tabled by the Honourable Member for Spen Valley, as it expands the protections for individuals to not participate in the assisted dying process if they so wish. This new clause seeks to protect employees from being subjected to any detriment for either participating or not participating in the provision of assisted dying. This is a sensible protection and ensures that if an NHS hospital is providing an assisted death service, that any member of staff doesn't want to participate, does not have to and won't suffer any detriment for that. However, there needs to be a sensible mechanism balancing this against the employer's right to set their own policy on assisted dying, and that is what my Amendment 10AC seeks to do, but we've already talked about that, so I won't go over that again. Right. I did want to talk about process and family, but it looks like I'm not going to have time to do that. So, Mr. Speaker, I will end there. I thank you for your patience and generosity in time, and I'm grateful that I've had the chance to speak in support of the members. And I look forward to hearing from other members today.
Dave Beghillier.
I'm just giving a minute to you.
To particularly talk about new clause 1 and new clause 2 in my name and consequential amendment number 2 and others which I'll touch on at the end. But these are, I would say, Mr. Speaker, and I'm not being at all dismissive of those who've helped me draft these amendments, but they are imperfect amendments. Those of us who are not the sponsor have not had the support of government drafters in tidying up this bill, and we need to acknowledge that the bill in front of us today is the bill, more or less, that will or will not be passed by this House. That any amendments made do not get, will then, at the point of third reading, and that is it. There will be no further opportunity to redraft them. And sadly, one of these in particular was rejected in committee. And we know that if those changes had been discussed before the publication of the original bill, or even in evidence before the Bill Committee, we would have been in a better place to get that tighter drafting that you do need in making good legislation. We are not a debating society, we are now legislating for a law that would enable the state to assist in people taking their lives. So I'm sad that we're only able to discuss these now. I didn't have the opportunity myself to be on the Bill Committee, but I do commend all members who spent so many hours discussing and debating those issues. But the ramifications for the clauses I want to talk about are very important for potential users of a service to be created, for medical professionals, for families and for other health professionals. The bill currently allows doctors to suggest assisted dying to a patient who has not raised it themselves. This, I believe, and I know many others do, presents a serious risk that terminally ill patients, already highly vulnerable, will feel pressured to end their lives. I'll give way to the Honourable.
I thank the Honourable Lady for giving way, and I realise this comes from a very good place, this amendment, but can she not see that this amendment is actually inconsistent with our ethical obligations as doctors? And that's why the BMA have suggested that there should be no duty to raise this issue, but nor should there be a ban on doing so. And what I also ask her to consider that Victoria in Australia did have this as part of their bill initially, a so-called gagging clause, and they had to remove it because it caused confusion and was detrimental to patient care. So should we not learn from what has happened? Thank you.
I thank the honourable gentleman for his point, and it brings me to a point I do really want to address. As I said right in my opening remarks, these are imperfect amendments. I have had, and I'll get into some of the conversations I've had with a number of people about this, but I'm one person. I have not been able to consult as a government or a sponsor could consult with the BMA, and I'm aware of their concerns. But we are talking here about decisions around life and death, a very definite and irreversible decision. So absolutely, and I have I know many doctors have had conversations, but not in the level that we would need to do to legislate on this, because this is, I think, a different set of circumstances. And I very much appreciate this point. I give way to my
Does she agree with me that there are far too many people who do not have confidence in the face of authority? And if a doctor raises assisted suicide with them, however tactfully or professionally, they will feel that they are being steered in that direction.
I thank my right honourable friend for that, and her many years of experience as a constituency MP in the same borough as me. We know many of those vulnerable people. And Dr. Rachel Clark, a hospital palliative care doctor, said if, for instance, you say to a vulnerable patient who's just been told they have a diagnosis of terminal cancer, have you thought about assisted dying? I would suggest that I, being Dr. Rachel Clark, that stating it broadly like that is a form of pressure and that you are potentially unintentionally coercing that patient. So we are in a very difficult space, as my honourable friend highlighted, as with his background as a practising GP. We recognise that, and as I said, Mr. Speaker, this is an imperfect process to deal with that challenge, but it is a very different set of circumstances compared with other improvised advice that the doctor gives around. Talking of doctors, I give way to the honourable.
I thank the right honourable lady for giving way, and I rise to support her new clause 1, because I'm very aware as a doctor myself of the trust that the public place in doctors and the seriousness with which they take what we say. And if a doctor tells somebody that they think or gives them information about assisted dying, it is quite reasonable for that person will think either the doctor is suggesting that they should take part in this process, or even they're hinting that their death is going to be a dreadful one and trying to be kind to them. And if doctors are able to say that this is a good process, more people will take it up than would otherwise have wanted to.
I thank the honourable lady. I need to get into some of my arguments. I have two clauses in particular to talk about, so I'm not going to take any more interventions for the time being. But I do believe this presents a really serious risk that terminally ill patients, already vulnerable, and already, we know of examples, it's not the debate to make those points about examples of patients who have felt very suicidal, very low at the point of diagnosis. At that point, they're very vulnerable, but often with good care and good pain relief can move away from that decision, but they could feel pressured into ending their lives sooner than they wish to, rather than be, and also the burden issues around family. And I need to make some progress. And I also want to talk about the issue of how the teenage brain works. This bill would apply to a child, to a young person at the age of 18, and a month or so after they reach that date of that birthday, after they reach that date, they could undertake an assisted death. And I want to talk a bit. I've had some very good conversations, and I'm going to highlight some of the people who've generously given of their time in enabling me to talk about some of these important issues. Issues that I am very worried have not been discussed at any point in the bill, except for that moment in Bill Committee where there was a short and important discussion, but nevertheless short. And I just wonder, if I can finish my point particularly about the issue of the age of doctors before I move on to the issue around 18-year-olds. Dr. Alexandra Mullock, who's a senior lecturer in medical law and co-director of the Centre for Social Ethics and Policy at the University of Manchester, said in written evidence to the Bill Committee, so it was provided to the Bill Committee, the freedom for a registered medical practitioner to raise or discuss the option of seeking to die in Clause 4.2 is ethically problematic. And she also highlighted that professional advice regarding treatment will be received by the patient as a recommendation, as the Honourable Lady just said. And that is a really big concern. And I just highlight one point from the UK Coalition for Deaf and Disabled People, who are very concerned and would like this removed as well. I give way to the Honourable Gentleman.
An excellent point. Does she also acknowledge that, given what we are beginning to know about coercive control, that the suggestion by a doctor, innocently, maybe neutrally, that this could be an option, could be latched onto by one who is coercively controlling someone who may choose assisted dying, and we will never find out until after that person's death, if at all, that that had been the case?
One does highlight an important point in relation to my amendments and others. But in this House, we have made coercive control an illegal thing. This was ruled on in legislation only in recent years, and yet this is such a big issue on an irreversible decision, and that is what is particularly different about this bill, and therefore why some positions are particularly challenging, because we're talking about irreversible decisions. But I want, Mr. Speaker, to talk a bit about how the teenage brain works. Children and young people are particularly susceptible to being influenced, including into dangerous and risky behaviour. And in a number of countries, assisted dying laws have been expanded to allow children and young people to end their lives. And we need to be very alert to that very real risk. And I'm impressed by the work of the Children's Commissioner, who recently published a report into children's views on assisted dying. And it was very heart-wrenching to read. Those with illnesses and disabilities were particularly concerned about what this bill means for them. These children haven't really had a voice in this debate so far. And there is talk about whether this may apply to children with life-limiting or severe progressive diseases. I'll give way to the Honourable Lady.
I thank the Honourable Lady for giving way, and indeed I also have great concerns about our young people. I was at an event in my constituency of Lagan Valley the other night, and it said that almost all of our young people across the UK are having their mental health impacted by social media. If we throw this into the mix, this has the potential to do untold damage. And I applaud everybody who has put the time to this today. I do have to say I do not support this, but I do applaud everybody, regardless of their view, in trying to make this better. But I have seriously grave concerns about the ramifications of this.
I thank the Honourable Lady for her comment. I'm going to touch, if I have time, on some of those social media impacts. But I do want to lay on the record my thanks to just some of the professionals who gave of their time to speak to me in preparation for this amendment. Sophie Scott is the Professor of Cognitive Neuroscience. If I could just, not the moment now, please. No, Sophie Scott is the Professor of Cognitive Neuroscience at University College London. Sally Baxendale, the Professor of Clinical Neuropsychology at UCL. Sarah Jane Blackmore, Professor of Psychology and Cognitive Neuroscience at the University of Cambridge. Dr Richard Hayne, Consultant and Clinical Lead, All Wales Managed Clinical Network in Paediatric Palliative Medicine at Cardiff and the Vale University Health Board. And Dr Anna Karinia Anderson, Consultant in Paediatric Palliative Medicine and Medical Director for Shooting Star Children's Hospice. I've had some very interesting conversations, and I'm only very sad, Madam Deputy Speaker, that this hasn't been a bigger debate as part of this, because the process hasn't allowed for that. And in the time I've got, I'm afraid, I apologise to them in advance that I will not be able to do justice to the very many and careful and thoughtful points that they raised. But I think it's important for the House to have an understanding of, I've said no, I need to get on to this. In the time I've got to explain and give due credit to the people who've assisted me in raising these issues. Adolescent brains develop differently. From the age of puberty, there's a very rapid change in how young people make decisions. And as adults, we have experience to imagine what a future might look like. But younger people up to about the age of 25, often can't plan or predict futures, and because that part of the brain has not developed well. And they're not good at understanding regret. And the comparisons here are different for adults. Role models and social groups matter a great deal. I'll give way to the Honourable Lady.
Thank you very much. I fully appreciate the Honourable Lady giving way and the time constraints, but I wonder if she would acknowledge that for many of us the concern with, first of all, not telling patients with all the options, and particularly with young people who are now so socially media literate, and the automatic reaction is to go and Google everything. In fact, we all do it. That the danger is, if they are not told all the options, if they are not given the guidance that's available, then they will go to Google, and what we will see is yet more of the dangerous suicide attempt that we see at the moment.
Well, I think the Honourable Lady made some points that I haven't got time to completely unpick, but I would simply say that to have something positively suggested, if you'll let me complete my argument, is a big issue for young people. And I think the social media aspect is an important one. But role models, the social network matters. At that point of puberty, teenagers particularly will look to their social group, which will massively influence their behaviour in a way that their family don't so much. And adolescents are more likely to take risks. Their neurodevelopment underpinnings are different, and the pathways between the rational and the emotional parts of the brain are not fully developed. And in a hot situation where there's a lot of emotion, they take more risk, and particularly because they don't have the ability to think about the counterfactual. And the counterfactual in this case is not being here anymore. It's a very difficult thing for a lot of people to understand, but particularly for young people. Their ability to think flexibly and change their mind is in the front of the brain, and that doesn't always doesn't react to the sorry, I'm trying to speak at such pace, Madam Deputy Speaker. I need to make some progress. Teenagers are passionate about their beliefs, and peers can change their mind in a way that often their parents can't. There's not always a logical decision-making path. A doctor would carry weight, and if the child may be thinking about it, and that somebody, that doctor, that professional, could make their decision a legitimate option, and that in response to the Honourable Lady from Edinburgh's point. There are very many issues in palliative care. We talk about Gillick competency. So just to be clear, that under the age of 18, young people can make own decisions about healthcare. Can they make their own decisions? They can make their own decisions about healthcare. And under the age of 16 even, you can have that conversation because of Gillick competency, which is a good principle. But the capacity and mental capacity and the issues around Gillick competency are often not well put in place. As some of the palliative care, I've said no to the Honourable Lady, the law itself is ambiguous about Gillick competency. We've moved on from the point she was trying to raise. Capacity in the Mental Capacity Act and Gillick competency, they triangulate through the person but also the condition. So it's not just a question it relates to the complexity of the condition, but also to the individual. Peer pressure, therefore, is a very big part of what has an impact on people, but also that view of the professional doctor. On that point, very brief. Sorry. Make some progress, and I need to move on. I just wanted to. I wanted to touch, Madam Deputy Speaker, on this issue about children making a decision at the age of 18. So you could have a conversation with someone about this, and then on your 18th birthday, sign on the dotted line. You would need another conversation at that point. But I think we need to understand that even at the age of 18 and 19, young people's brains are in a different place on this. And we are saying, if we pass this bill, that at the age of 18, 19, 20, you could have an assisted death. We need to understand the ramifications of that for the people who could have that in play. And I wanted to make sure that I'm covering some of the other points that other members have laid. I won't go through all the amendments that play into this, but I do think that strengthening the panel, the safeguards, the other amendments down to do that, which I haven't got time to list, and the coercion and capacity issues, which many members have raised, are very, very important in this regard. But there hasn't been the time to work through how these issues have an impact on younger people. If only I had time to go into some of the evidence I had, and I've given it, I'm afraid to say, only just a very hasty run-through because of the needs of time on this day, which is a sign, Madam Deputy Speaker, I think, of the challenges of this process, that we haven't got time to go into the detail that we need to do. But socialisation is important, so social media has a very big impact, and we need to understand that that will have an impact on young people making their decisions. I'm just trying to do the maths on my timing. Madam Deputy Speaker, I fear I have run out of time. I would like to speak for longer, but I'm getting the mood of the House and the mood of the Chair that you do not wish us to do that. I am very concerned about this not being properly discussed. And I would just again remind members, if we vote on this bill, these matters have not been fully tested with the professions concerned, as we've heard from the Royal College of Psychiatrists this week, and from many of the others that would need